Predicted. As if they were Al-Qaeda criminals. Or Al-Shabaab. By my learned colleagues. So what we shall be submitting on is try to make some apart from the and taking off from the charges that are before this court. In Kiambu, miscellaneous criminal application number by the Honorable Mr. Honorable Gideon Moi, the Chief Magistrate. Kiambu. Magistrate of Kiambu. detention of Ms. Wanjiku Vega.
When there's a scenario of demonstration, and no, your own.
He was inviting the court to check judicial law.
Yeah.
That is what he said.
That is my point. Yes. I was calling the court to decision on what is happening, of people taking advantage of protest and demonstration.
Please allow me to give directions. I think the state was very silent and allowed you, and I think there is room at the point of making rejoinder to point out any issue that you may think that the court should take care of.
Yes, Your Honor. And you know, this is where the heart of all this is falling, and that's why you can see the reactions. We are trying to show the court that indeed these are terrorist acts because they were done judicially just. This guideline was given to a prosecutor. That when a prosecutor, it can be checked. But how can we check it? We can only check whether DPP exercised this right. And this right is not for me. My colleague will proceed from there.
Your Honor, I would not want to. There was endangering of human lives, and these are all articulated under the Prevention of Terrorism Act, are clear and are proper, and have been made under our mandate. Come later, we will be able to present whatever we have so that we are able to support this count. Therefore, Your Honor, we submit that the charge be.
And Your Honor, with a bit of hindsight, and I'm quite sure, Your Honor, that no Kenyan will look at these young people and call them terrorists of the act. And, Your Honor, as a terrorist, is on conviction to imprisonment for a term not exceeding 30 years, Your Honor. And this is a person who is notice of the situation in the country, where it is already publicly pronounced that over 500 others are charging these Kenyans and others with terrorism, the offense of terrorism, serves only the... Everything else flows out of that. We've already dealt with the matter of adequate notice and public notice everywhere. Seen on screens, some of them numberless. Your Honor, I want to advise strongly the Office of the Director of Public Prosecution. Yes.
Senior counsel. Yes.
We here? Okay.
Please proceed.
Thank you, Your Honor. This matter is not about advice to the DPP. And I believe that once Council is acting on our mandate.
Very well.
So Council should desist and resist.
Order, Mr. Machira. Your Honor, whatever it is worth, I don't want to respond.
Yes, please carry on.
Objections must be on a point of law.
Yes.
And I have not had any point of law raised.
Indeed.
Your Honor, this is the objection.
Now, yes, please. Can you
The submission by the senior counsel are intended to align
word that is uttered by the other side, inflame the opposite side, and we will feel like
Much obliged.
and then we will generate into an exchange of words.
Your Honor. For example, you can be charged. And therefore, we invite you to agree with us that the Deputy Chair of LSP to add what I've just said.
I think Senior Counsel, whereas probably Senior Counsel Bar pertinent to law. Pertinent to law. Your Honor, at this point you will note that on the question of yes, an initial report, it says must. There's a famous, shall any relevant documentary exhibits as a matter of caution and very important, especially on this first count, to confirm the age of the suspects as an administrative body to prosecute cases on behalf of the state. This is a power that the court regulates from time to time. And so with a lot of humility and respect, as my colleagues from the DPP are stating, we urge the court to regulate the conduct and the affairs of the Office of the Director of Public Prosecution. Now, Your Honor, if we may look at a cursory reading of the statement of facts, the persons before you cannot respond if a plea was to be taken. We have watched, as Kenyans, persons wearing the National Police uniform on signal, vandalizing private property in the company of members of the public in Kenya. The tragedy of allowing such a charge to proceed is that even though it may be saved at the end, probably with a discontinuation or termination of the charges, prejudice will have already occurred on the persons before the court. The reading of Section 4 cannot be isolated from the definitive definition of the term terrorist act. And because we have time, limited as it is, Section 2, and I will read it, says, prejudices national security or public safety, and then proceeds to put a rider and says, and. So this charge, in the particulars, cannot be left in isolation by saying, committed a terrorist act. It has to go with the sub B, which states with an aim. Mental state, what we call mens rea, is very important because the persons before you must respond to either of the three and not all. If they had to respond to all, then in the particulars of the offense, it will have captured it that way. But, yes, that the persons before you make, that the statement, the particulars of the offense cannot be read in isolation without the mental state, the mens rea, intended to do what? So that it says, and, which is carried out with an aim So it particularizes them in three. One is to intimidate or cause fear amongst members of the public. If I am too fast, Your Honor, you could ask me to slow down. Yes. Number two, intimidating or compelling the government or international organizations to do or refrain from any act. And lastly, destabilizing religious, political, constitutional, economic, or social institutions.
This is the mens rea.
Yes, yes. So that as they are responding, if they will, the court will find that they should respond. They need to respond to a charge which is holistic. It is inclusive of what they intended to do. Now, finally, what the statement of facts states, and if the court will be minded to also look at the other count 2 and count 3, they are extremely identical to count number 1, with the exclusion of the term committed a terrorist act. Now, if the court would be minded to entertain all 3 counts, things before the court will be doing would be to suffer not even double jeopardy, there's something like that. A criminal law lecturer will have to revise his manual, will be triple jeopardy. Because what it says generally is that property was damaged allegedly by the persons before you. Of great importance as I sit down, and this has not been addressed, it cannot be possible to commit acts under Porter when Article 37 exists, and the court will take judicial notice that in the charge sheet falls squarely on a date that Article 37 was applicable. And that being the case, the drafters of Porter would have stopped Section 2B and not included the proviso that I will read it for the court as it retires, provided that an act which disrupts any services and is committed in the pursuance of a protest. In fact, Porter does not use the description of the. It foresees that such protest may not be peaceful. So that as we have seen, allegedly there was property that was destroyed or damaged, and it continues to say, demonstration or stoppage of work shall be deemed not to be a terrorist act within the meaning of the definition, so long as the act is not intended to result in any harm referred to in A1 to 4, which is the present case. On that date, materially, the court should take judicial notice that there was a countrywide demonstration pursuant to Article 37. As the court is winding up and retiring, Your Honor, we all come from different backgrounds and we all have things we do in life. I was once told by my grandmother that even a mortician has rights. For instance, those who work mortuaries or places or funeral homes may picket and demonstrate when their workload goes down. What I mean is that when the mortality rate of Kenyans go down, Kenyans are not dying, morticians may complain. The work of the Director of Public Prosecution is not an easy one. It is akin to that of a mortician. And there are our colleagues on that side. And I need changes. At one time in this country, any person who was urging, I will not talk much about it because we are being led by senior counsel, and he's my friend. It was meant to be a joke, but everyone is serious. Today, the persons before this court, the persons who are intended to be charged, but tomorrow, they may be our heroes. I urge this court as it retires with the utmost humility, because now I'm like the EPP, I mean count number 1, because we will come to discuss the other counts. As I had said on the question of jurisdiction, it is our position that on the second count and the third count, jurisdiction to deal with this matter under the CPC as section 71. So these alleged offences were not committed within the precincts. Other courts which can deal. I know the DPP is itching to say that the Kikuyu court is not functioning. But there is another court nearby which can handle.
Referred to by Mr. Moi. Mr. Moi want to convince you that there are 2 parts of that proviso that can occasionally deemed not be terrorists act within the meaning of the definite of the referred to in paragraph A, Roman 1 and Roman 4. Roman 4 is what is of our interest. He tells you that this should be the act of protest, demonstration, or stoppage of work. That is the act which the proviso is not to the burning, destruction, or anything. It's to the action that has originated. Why am I on the street? To demonstrate. I urge you to rely on the golden rule of statute interpretation. It will not lead you to arriving to the absurdity and the mischief being actuated and perpetrated by the ODPP. The golden rule the golden rule, when it's used for interpretation, would lead you to arriving at a decision that when such an interpretation would lead to unreasonable or nonsensical results, to which the DPP is inviting you to. I rest my case.
Yes, Your Honor. See for the strong words by counsel, especially the one here about nonsensical stuff. I want to respond to that because I know that decision to charge is a very solemn decision. And a lot of repercussions. And we have taken the decision bearing in mind the response. And especially also bearing in mind the current circumstances that we are all as Kenyans are undergoing. And just to, before I sit down, I just wish to say that there is a lot of misunderstanding on the import of the exemption.
Coming from?
Just give him an opportunity to respond to any.
I don't think he has audience, Your Honor, with due respect, and we wish to object to that
Yes,
because we are now reopening the case. Fortunately, that is the rule, and the court must be bound by those rules. We can't make our own rules.
I understand.
Yes.
Yes, I also
as much. And,
understand.
Council only to limit as much. And when Mr. Mashira rose on his feet, I said to him, reserve anything that you want to say, and I'm not opening up for the prosecution to make any new submissions.
No, yes.
And to leave it there.
You know, I am well guided, but I still insist that unless the court wants to make its own rules that governs proceedings, that this gentleman, the DPP, has no audience before you. And I would wish you to make a ruling on that, Your Honor. I make an application that will make a ruling on that.
Your Honor, with tremendous respect, the Law Society is here and we represent Mr. Ndegwa. We are asking.
Yes, Your Honor. Yes, and thank you.
Not to reopen any new issues.
Yes, thank you. Thank you to the Deputy.
Of course, we'll be making the same application.
Yes.
If we can simply proceed with those two.
Indeed, I think even over time.
And in those two, will mostly be adopted.
Good. So, the state is in agreement?
We are in agreement.
Call out the next part. So for the accused persons in E08 of 2025, you may be seated. Wale ambao wameitwa kwa kesi ya Daniel naweza kutafuta mahali hapo kazini. Those that are remaining, please call it out.
Criminal number 70, 2025, State versus Peter Kinyanjui, alias was Sarah Wanjiko.
Yes.
They should be here.
Peter
and Sarah.
Please call them. Please call them. Please, let me.
Six constitutional questions.
Because this is a fresh matter.
This is a fresh matter.
And we are taking quorum in this one as well.
Thank you.
So, Mr. Mjiri is the new council that is coming into Mr. Nguinga. Yes.
Yes, there's an element of serious persecution. The officials of the DCP, Democratic, a party in coalition with several others, including those represented by County Honorable Gachagua, Rigathi. That we are seeing state high-handedness. Whenever they hear the name Rigathi Gachagua. I'm going to invite Council Kibe Mungai to highlight the circumstances. The state feels is not towing their kind of political line. He is haunted and charged with terrorism. And I therefore want to invite Wakili Kibe, because these two were even admitted as if they were Al-Qaeda criminals or Al-Shabaab and counted to prison.
All the submissions that have been made by my learned colleagues so what we shall be submitting on is try to make some apart from taking off from the charges that are before this court. Number one, in Kiambu, miscellaneous criminal application. One of the Sarah Wanjiko Vega was the second respondent. The Honorable Honorable Levi Kiberu, the Chief Magistrate of Kiambu, of Ms. Wanjiko Vega. Had made a similar application. That case in Roiro is criminal, miscellaneous criminal case number E465 of 2025. We shall make arrangements to furnish this court and the prosecution, if they do not have already, the said two rulings. In those two rulings, Your Honor, the summary is the offenses, particularly the particulars of the offenses, facing those two accused persons are exactly the offenses that has precipitated their arraignment before this court. There are in both those two rulings your honorable learned colleagues, the chief magistrates, ruled that the prosecution had not tendered the required evidence or grounds to justify their further detention. Complying with the orders made by your honorable colleagues, deploy the anti-terrorism officers, ATPU, to invade the hallowed precincts, of the court, and for all practical purposes, abduct those two accused persons for purposes of the current arraignment that is before you. Your Honor, it is unfortunate that yesterday we were unable to access our office since Friday after they were abducted at Ruto and Kiambu law courts. I had an intention to bring an important authority from the House of Lords known as Bennett versus Horseferry Roads Magistrate. A decision from England. From South Africa, pursuant to the extradition treaty, they decided to do a basically to get Bennett from South Africa, get him to England, and charge him. Bennett challenged his prosecution on the ground that there could be and there cannot be lawful criminal proceedings pursuant to an unlawful and unconstitutional act. There can be there is absolutely no validity. In the ultimate, the House of Lords allowed the objection, Bennett. One of the best decisions one can read, and basically saying that my senior counsel can read this.
Yes, yes indeed, Your Honor. It's Bennett versus Horseferry. Horse as in horse. Okay.
You can read the one.
That's very good. Your Honor, some of these passwords are for the family.
Indeed.
This prosecution, Your Honor, applied to this particular case, the issue is simple. The accused persons, once an order has been made, and it used to be civilized a long time ago, once an order has been made that a person has been admitted to bail, it must mean at the very minimum that that person must spend a night in their home, in their house. Otherwise, it would mean that the only choice that the magistrates at Ruto and Kiambu had was to agree with the prosecution. And if you disagree with the prosecution, we abduct within the same courts and bring somebody to committee. Is it called Karua or committee? This one. Karua. And bring somebody to anti-terrorism court.
But the nature of the confinement, you are right to call it committee.
Exactly. So that you,
Your Honor,
yes,
I'm going to change country.
you will add anything after me. So that, Your Honor, the issue, and it should bother the conscience of this court. Because what's the image that the prosecution and the police, anti-terrorism police, are projecting? That those people that we cannot prosecute on a low threshold of law, we take them to Kahawa law courts, the anti-terrorism law courts, on the same issues, on the same charges, on the same facts. My Lord, if that were to be the case and were to be permitted, it would mean that the critical gain under the 2010 Constitution in terms of ensuring that the courts are not an executive branch and an extension of the executive arm of government would have come back. The courts in Ruto and Kiambu did act independently. And so the accused person asked me one thing. Why is the state confident that monkey business that is not possible at Ruto and Kiambu is possible before the Karua law courts? You know, we beseech you we shall instead take people to Kahawa. You know, I had some objections to arrogance. Arrogance does not come worse than this. That you are required by law to go to the High Court, you choose not to go to the High Court, and you decide we are heading to Kahawa. Why? Because it is an anti-terrorism court. We shall get back to that. It is still a court in Kenya, my lord. Your Honor. Your Honor, the second part of these orders from Kahawa were this. The prosecution was beseeching those courts to complete investigations. That's why they needed their detention. And the rulings were based on the fact that the prosecution failed to produce the evidence as required by the law. Is it 24A? 24A? 6C? 36A. Under 36A of the CPC. That is the legal facts as far as this matter is concerned. You are sought for 21 days to complete investigations over those very same facts. So that, Your Honor, and here I'm speaking about abuse of court process and abuse of power. It is obvious that, and the law is, as we had submitted in Kiambu, that before a person can be lawfully prosecuted and take a plea, the of evidence that must be reached. The position of the prosecution, that is the subject matter of the ruling of 4th of July, is that we do not have that evidence. And effectively, the courts were basically saying, let them be out. They gave conditions twice a week to compare the less here because the prosecution and the state would hear none of that. They don't even have High Court. Because the moment those rulings were made, only the High Court could vary that position. That if you wanted, your magistrate said, you needed to go and convince a judge of the High Court that these are such dangerous people that your landed colleagues at Roiro and Kiambu got it wrong, and we must detain them. That has not happened. And it is the reason why we say the arrest and arraignment constitutes abuse of power, and the charges that they have preferred and want to be registered before this court constitute abuse of court process. This, Your Honor, I beseech you not to permit the prosecution and the Kenyan state to do this. Because it would mean that the Constitution means what the police and the DPP says it means. Your Honor, under our law, the Constitution is written, we know its meaning, and in terms of dispute, it means what the courts have interpreted. If the magistrates in Roiro and Kiambu got it wrong, get another interpretation of the meaning of our laws from the High Court. Anything short of that would turn this country into a police state. And Your Honor, we cannot have so that, Your Honor, to get into those other 5 points, now that you have that background, Your Honor, it is important that we point out that for purposes of Section 4 of the Constitution, Kenya is a constitutional democracy. That is Sections 4.2. And it is a constitutional democracy in which the values and principles referred to in Article 10 applies. One of them is to ensure that there is protection of law and the Bill of Rights. we submit that in a situation where a serious issues arise as to what is the correct conduct for a constitutional democracy, you cannot be able to say you have valid charges. In short, Your Honor, therefore, we are beseeching this court to make a finding that in a constitutional democracy, like it was done in Bennett versus Osfery in England, this kind of state conduct cannot be permitted. Secondly, Your Honor, is the issue of Article 38. Your Honor, the issue of Article 38 is important because that is the rights that were being exercised on the material day, the 25th of June, across the country. And it is important because my learned colleagues had said something about it, just for me to say that in the defined purposes, I believe, of Section 4, there is a proviso that is made. Yes. Yes, there is a proviso that is made that that is Section 2 actually, that with regard to that where a protest stoppage of work, that there is an attempt that is made by the Anti-Prevention of Terrorism Act to make sure that this law would not apply to certain kind of actions of a political nature. Your Honor, it is our submission that this proviso in Sections 2 of the Prevention of Terrorism Act was meant to ensure that in enforcing, in the implementation of the Prevention of Terrorism Act, the state would not cross the boundary, because actions that are genuinely and undoubtedly of a terroristic nature are punished separately from actions, any inconvenience, any destruction of property that happens in the course of pursuance of a political cause.